All right, let's get right into a case that every law student absolutely needs to know. Afcons versus Cherian Varkey. Now, this isn't just some dusty old judgment. This is the story of how the Supreme Court literally had to perform emergency surgery on a broken law, and in doing so, saved the future of dispute resolution in India. I mean, just look at this quote. When the highest court in the country calls a law a nightmare, you know things are bad. This one statement perfectly captures the absolute chaos that Section 89 of the Civil Procedure Code was causing for judges everywhere. And that's the big question we're tackling in this explainer. How did a seemingly straightforward fight over construction payments spiral into a situation where the Supreme Court had to step in, not just to interpret the law, but to basically rewrite it so it would actually work? So first things first, let's get a handle on the problem itself. What was so fundamentally wrong with Section 89 of the CPC? Why was it such a nightmare? You know, the intention behind Section 89 was actually fantastic. The whole idea was to lighten the load on our courts by encouraging things like mediation and arbitration. But the way it was written, it was a mess. The Supreme Court itself said its great objective was completely crippled by drafting that was confusing, impractical, and, let's be honest, pretty much impossible to follow. So you've got this flawed law just sitting there, like a ticking time bomb. And the case that finally set it off was a dispute between Afcons Infrastructure and Cherian Varkey Construction. Let's dig into the facts. Okay, so the setup is pretty simple. Afcons hired Cherian Varkey as a subcontractor. A dispute over payments comes up and Cherian Varkey suits. Now here's the most important part. Their contract had no arbitration clause. None. But the trial court, pointing to Section 89, ordered them to go to arbitration anyway. And Afcons, understandably, said, "No way, we never agreed to this." In this, right here, is the central legal question that everything boils down to, a question with massive consequences for our entire justice system. Can a judge actually force people into arbitration when they haven't agreed to it? So, in one corner, you had Cherian Varkey. Their argument was pretty bold. They said, yes, the whole point of Section 89 is to give courts the muscle to push cases toward ADR, and that includes ordering arbitration, even if one party is kicking and screaming. But Afcons fired back with a fundamental principle of law. They argued that, hey, arbitration isn't just a friendly chat. It's a formal process that leads to a legally binding decision. You can't just force someone into that. They insisted that consent is the absolute foundation of arbitration. Faced with this clash, the Supreme Court didn't just pick a winner. It basically put Section 89 on the operating table and conducted a full diagnostic, uncovering two huge problems, or anomalies as they called them, that made the law such a mess. The first anomaly was just baffling. The law literally got its own definitions for judicial settlement and mediation mixed up. It was like reading a dictionary where the definition for cat was a loyal animal that barks and the one for dog was a feline that purrs. Total confusion. And this slide just lays it out so clearly, doesn't it? The law used the term judicial settlement, but then gave a definition that perfectly describes mediation. And then it used the term mediation, but described a process led by a judge. The court basically said this looked like a pretty obvious clerical or typographical error made by whoever drafted the law. The second anomaly was pure procedural nonsense. It was a classic case of putting the cart before the horse. The law said a judge had to come up with the terms of a possible settlement and show them to the parties before sending them to a mediator. Think about that. It's asking the judge to do the mediator's job, which makes sending them to a mediator totally pointless. So what do you do with a broken law like this? You can't just throw it out because the goal was a good one. Instead, the court picked up a powerful legal tool called purposive construction. Basically, it decided to interpret the law in a way that would fix the errors and actually achieve its original purpose. First up in the judicial surgery, they fixed the definition mix-up. The court simply said, from now on, we're reading these as if they were swapped. Mediation means what we all think it means, using a neutral third party. And judicial settlement means what it sounds like, a settlement process helped by a judge. Boom, instant clarity. Next, they tackled that cart before the horse problem. The court reinterpreted that clunky phrase, formulate the terms of a possible settlement. They said, look, all this really needs to mean is that the court should just give a quick summary of what the fight is about before sending the parties off. So simple, so practical, absolutely brilliant. But the court didn't just stop at fixing those two things. No, it went way further. It laid out a brand new, crystal clear framework for every single civil court in India to follow when using Section 89. And this is the true game changer, the lasting legacy of this entire case. This table breaks it all down perfectly. The court drew a big, bright line. On one side, you have adjudicatory processes, things that result in a binding decision, like arbitration and conciliation. For those, the court said consent from everyone is absolutely mandatory. But for the other three, which are more like guided negotiations, the court can refer a case even if the parties don't agree to it. And then the judgment laid out the super clear 5-step procedure that all courts have to follow. But the real genius here is step 5. If the parties say no to arbitration or conciliation, the court doesn't just give up and go to trial. It must then refer the case to one of the other 3 options. This creates an amazing safety net that finally makes the push for ADR effective. Now, to make life easier for judges, the court was also super helpful and laid out the kinds of cases that are just not a good fit for ADR. We're talking about things with public interest involved, serious criminal stuff, or cases where the court needs to protect someone, like a minor. And on the flip side, it gave a huge green light for pretty much everything else. All your normal business disputes, family matters, contract fights, and consumer complaints, all of these are perfectly suited for ADR. This guidance has been a massive help to the lower courts. So, after performing all this incredible judicial surgery and creating a whole new framework from scratch, what was the final call in the case that kicked this whole thing off? Well, the final ruling was as clear as it gets. The Supreme Court sided with Afcons. It held without a doubt that a court cannot force anyone into arbitration without the mutual consent of all parties. The trial court's order was overturned and the appeal was allowed. A huge victory for the principle of consent. And this leaves us with a really big, fascinating question about the role of our courts. The Afcons judgment is a masterclass in solving a practical problem for sure, but it's also a huge act of judicial interpretation that comes very, very close to rewriting legislation. So it makes you wonder, where do you draw the line between interpreting a law and rewriting it? And in this case, was the Supreme Court right to cross it?